Patents and trademarks are territorial and must be filed in each country where protection is sought. A U.S. patent or trademark does not afford protection in another country. The Madrid Protocol makes it easier to file for trademark registration in multiple countries. By filing one trademark registration application with U.S. Patent and Trademark Office, U.S. applicants can concurrently seek protection in up to around 84 countries. The protocol relating to the Madrid Agreement concerning the international registration of marks, the Madrid Protocol, is one of two treaties comprising the Madrid System for international registration of trademarks. The protocol is a filing treaty and not a substantive harmonization treaty. It provides a cost-effective and efficient way for trademark holders to ensure protection for their marks in multiple countries through the filing of one application with one single office in one language with one set of fees in one currency. Moreover, no local agent is needed to file the application. While an international registration may be issued, it remains the right of each country or contracting party designated for the protection to determine whether or not protection for a mark may be granted. Once the trademark office in a designated country grants protection, the mark is protected in that country just as if that office had registered it. The Madrid Protocol also simplifies the subsequent management of the mark, since a simple single procedural step serves to record subsequent changes in ownership or in the name or address of the holder with the World Intellectual Property Organization's International Bureau. The International Bureau administers the Madrid system and coordinates the transmittal of requests for protection, renewals, and other relevant documentation to all members. An international registration lasts for 10 years from the date of registration and may be renewed for additional 10-year periods by paying a renewal fee to the International Bureau. These are the steps in the registration process. In Stage 1, you file an application through your national or regional IP office, the Office of Origin. Before you can file an international application, you need to have already registered or have filed an application in your home IP office. The registration or application is known as the basic mark. You then need to submit your international application through this same IP office, which will certify and forward it to WIPO. In Stage 2, this entails a formal examination by WIPO. They only conduct a formal examination of your international application. Once approved, your mark is recorded in the International Register and published in the WIPO Gazette for International Marks. The WIPO will then send you a certificate of your international registration and notify the IP offices in all the territories where you wish to have your mark protected. In Stage 3, this involves a substantive examination by national or regional IP offices. The IP offices of the territories where you want to protect your mark will make a decision within the applicable time limit, usually 12 or 18 months, in accordance with their legislation. WIPO will record the decisions of the IP offices in the International Register and then notify you. There are three possible outcomes of this examination by a member's office. First, you receive nothing, which can be seen as tacit acceptance within the 12 or 18-month limit. This means protection is considered granted. In other words, no news is good news. The following words will be stated in your trademark record in WIPO's official status database, the Madrid Monitor. Quote, "The refusal period has expired and no notification of provisional refusal has been recorded. Application of Rule 5 preserved." End quote. Secondly, another outcome would be that you receive a statement of grant of protection. If an office finds no grounds for refusal, it must issue a statement of grant of protection for your mark. This statement is comparable to the domestic registration certificate issued by national or regional IP offices. If you've designated Cuba or Japan, you will also receive a request to pay the second part of the individual fee at this stage. Thirdly, another option would be that you receive a notification of provisional refusal. If an office finds grounds for refusing protection of your mark, either in its entirety or partially, it must send a provisional refusal to WIPO. They will then transmit this provisional refusal to you. The notification will include reasons for the refusal, any further steps that are required, including the time limit to respond, review or appeal options, and whether or not you must appoint a local agent to assist you. If an office issues a provisional refusal of your mark, it must follow up with a final decision. There's no time limit for the office to issue this final decision. The timing of the final decision will depend on whether or not you have challenged the provisional refusal. So you could have a positive outcome where the office grants protection of your mark for all or some of the goods and services listed in your international registration, or a negative outcome, the office confirms a total provisional refusal of your mark. In some cases, you may be able to appeal this final decision to a higher judicial or administrative body, such as the Board of Appeals or court. This will depend on the domestic laws of that member. Once your mark has been recorded in the International Register, the Madrid system makes it possible for you to manage your international registration via a single centralized system. For instance, a single submission is sufficient to either totally or partially transfer or renew your international registration in multiple countries or regions, or to appoint a new representative before the WIPO. You can also record changes to the holder's name and address, request a change in ownership, or restrict the scope of your international registration. The establishment of the World Trade Organization's TRIPS, or Trade-Related Aspects of International Property Rights Agreement in 1995, this changed the face of international intellectual property law and policy making. TRIPS negotiators recognized that shortcomings and inconsistencies in IP protection can distort trade and impede its benefits. The TRIPS agreement helps ease trade tensions about IP issues while leaving WTO members ample space to pursue diverse domestic policies. The TRIPS agreement sets out general principles and minimum standards for the protection of IP that aim to facilitate and promote trade in knowledge-rich and value-added goods and services. But its negotiators consciously left room for maneuver so governments can adapt domestic IP laws and policies to safeguard important national interests. For instance, a critical concern has been to sustain a balanced approach to the role of IP in ensuring public health, an approach affirmed by WTO ministers in the 2001 Doha Declaration on the TRIPS Agreement and Public Health, which recognizes the importance of access to medicine. Developed countries were given until January 1996 to apply TRIPS standards in their national legal systems, while developing countries were granted a longer time frame, until January of 2000. Least developed countries were given even more time. For all WTO members, especially developing countries, implementation of TRIPS standards ushers in a process of passing new legislation or updating existing legislation, as well as strengthening the expertise and building the institutions needed to effectively administer and enforce intellectual property. The agreement sets these standards by requiring first that the substantive obligations of the main conventions of the WIPO, the Paris Convention for the Protection of Industrial Property, and the Berne Convention for the Protection of Literary and Artistic Works, in their most recent versions, must be complied with. With the exception of the provisions of the Berne Convention on Moral Rights, all the main substantive provisions of these conventions are incorporated by reference and become obligations under the TRIPS agreement between TRIPS member countries. The TRIPS agreement also adds a substantial number of additional obligations on matters where the pre-existing conventions are silent or were seen as being inadequate. The TRIPS agreement is thus sometimes referred to as a Berne and Paris Plus agreement. Cancellation of a mark on the grounds of non-use cannot take place before 3 years of uninterrupted non-use has elapsed, unless valid reasons based on the existence of obstacles to such use are shown by the trademark owner. Circumstances arising independently of the will of the owner of the trademark, such as import restrictions or other government restrictions, are recognized as valid reasons of non-use. IP lies at the center of efforts to gain benefits from innovation and creativity in today's global economy, while the TRIPS agreement continues to play a critical role in facilitating trade and knowledge, in resolving trade disputes over IP, and in assuring WTO members the latitude to achieve their domestic objectives. International trademark infringement occurs when someone violates the rights of a trademark holder in another country. In one infringement case, Apple sued Samsung for infringing on their design for the iPad and iPhone and using the design for the Samsung S4G. The case took place in the United Kingdom, and the judge ruled against Apple. Apple requested that the court issue an order that would have prevented Samsung from selling their smartphone in the United States. They also wanted punitive and actual damages and a ruling that Samsung had willfully infringed on their design. In his ruling, the judge found against Apple because Samsung's smartphone did not have the subtle, simplistic design for which Apple products are known. As a result of losing the lawsuit, Apple was required to publish an announcement on its United Kingdom website that absolved Samsung of the claimed infringement. This notice had to remain on the website for 6 months. Apple had to publish the same notice in magazines and newspapers to help restore the reputation of Samsung.